and then but I'll be introduced. Then I'll be basically setting up the roadmap and everything. Would you like to have a brief of the case itself and the issues?
I think it's okay. Just do a regular submission. Yeah.
Okay, sure. Sorry. Okay.
Okay, appellant can start when you're ready.
So, Ivana, am I audible, or is there any interference or anything?
No, it's okay.
Sure.
Yeah.
Right. Okay. Good evening, Madam President, and members of the panel. My name is Maxwell Peter, and together with my co-counsel, Mr. Brandon Zhang, we represent the appellant, Mr. Antonio Fortuna. I will address issue A, the admissibility of appeal, and issue B, the lawfulness of the refusal to surrender the mobile phone. My co-counsel will then address the remaining two issues. Madam President, my submission on admissibility proceeds in three steps. First, I will explain when the appeal began to run and why it runs from the receipt of the motivated decision and not from the earlier unreasoned confirmation. Second, I will show the CS jurisdiction was validly seized and that the alleged defect concerns only a procedural delay, not admissibility. And third, even if the panel considers the appeal to have been received late, I will submit that the reinstatement is warranted.
What is the difference between jurisdiction and admissibility?
Madam President, the difference between jurisdiction and admissibility is that we would like to explain that the admissibility of the submission itself is starkly different from the jurisdiction itself, because when Madam President, the jurisdiction here is the power of hearing the claim by the CS tribunal, whereas admissibility is the admissibility is whether they should exercise and let the hearing be heard in the CS panel. And third, even if the panel considers the appeal to have been received late, I will submit that the reinstatement is warranted because the delay is attributable to the counsel of the athlete and not the athlete himself. And the appellant acted promptly and in good faith. Madam President, I will begin with a concession. We accept that the statement of appeal was treated as received late by the CS court office. We do not dispute that fact. However, the concession does not end at the inquiry because the appeal runs from the receipt of the motivated decision, and the delay is attributable to the counsel, not the athlete. The appeal
Can
period.
you point me to the part of the case that shows the dates of the release of the motivated decision?
Yes, Madam President. So, if I may direct you to paragraph 26 of the record. So 26 and paragraph 27 of the record clearly states that the appellant paid a filing fee of CHF 1,000, filed a statement of appeal against FIFA before the Court of Sports of Arbitration. And on 24th April 2026, the appellant also sent a statement of appeal to the CS by courier.
Hmm.
Yes, ma'am. So, with the fee, the decision was upheld on 31st March 2026, but communicated with grounds only on 2nd April 2026, according to Exhibit 7. So, in essence, the receipt was the decision was made by FDC, but they had not given a reason, or the reason why they had not communicated the reason as to why they have dismissed the appeal itself. And it was only on the 2nd of April that they sent out the documents. The
Is
distinction. Sorry.
are the appellate tribunal or whatever obliged to give reasoning regarding their decision?
Yes, Madam President, because without the reason, they the the appellant will not be able to claim or will be able to contest the matter if he doesn't know what the dismissal was about.
I mean, what is the authority you're trying to point to for saying that the appellate committee is obliged to do so? Is it in any certain rules or whatever?
Yes, Madam President. So CS has consistently recognized a principle from the CS case of Ivan Bilardo, where on paragraph 75 and 76 it was held that the appeal period only begins once the reasoned decision is communicated. And because without reasons, the right of appeal cannot be exercised efficiently. So applying the logic over here, the motivated decision was received on the 2nd April, according to paragraph 26, Exhibit 7, and the statement of appeal was filed on 23rd April 2026, according to paragraph 27, Exhibit 8. The appellant then, with using this flow of logic, the appellant acted within the correct legal framework. Now, Madam President, I would like to also I would like to now move on to paragraph 27 of the record. At paragraph 27, the appeal was filed within file and the filing fees was paid. On 29, the CS informed counsel that the appeal had not been received. And on paragraph 30, on 30 to 31, the counsel immediately explained the failure and requested reinstatement and attached a screenshot of the email as per Exhibit 8 of the record. Critically, nothing in the record states that it was a fault by the athlete himself, but rather the counsel of the athlete was to be held liable for such problem. Mr. Fortuna had instructed the client in time, paid the filing fees, and had acted promptly and transparently according to paragraph 29 and 29, 30, and 31. The CS jurisprudence.
It's just bad luck, right? So basically, the appellant should sue the counsel for malpractice. Why does it have to do with this tribunal hearing the case?
Madam President, because the appellant's counsel had also faced an issue, which was there was a cyber attack in his law firm, which we can see on record at paragraph 30. So the CS jurisprudence distinguishes between jurisdiction seizing acts and procedural defects. In the CAS case of Christina Iwov and International Wrestling Federation, the panel held at paragraph 66 that jurisdiction is seized by the statement of appeal and that defects in the later procedural steps do not automatically render the.
But you see, the reason here, right? The case authority you're mentioning about is about jurisdiction.
Yes, ma'am.
But here, we're talking about admissibility.
Yes, ma'am. But on the at paragraph 70, the case also mentions that the procedural step do not automatically renders an appeal inadmissible as in the case itself. So
Then
it also,
what is the underlying rationale of that case saying that it should be admissible?
ma'am, the underlying rationale of this case is that just because the appeal was not filed in time doesn't mean that the defects should automatically render the whole application inadmissible. We should be looking at the system. We should be systematically looking inside as to why the appeal was submitted late. And in our case, we see that it was due to the counsel, and the counsel had a cyber attack in his law firm.
So what is the reason in that case for the appellants to miss the appeal deadline?
Madam President, in this case, the statement of appeal and the defects the statement of appeal was not received on time because the appellant's counsel had the same issue and they were not able to furnish.
You mean the case authority you refer to also?
The case authority, madam.
Also, the counsel met the technical issue,
Yes,
which is
madam.
related to computer, so that at the
Yes,
end,
madam.
the tribunal. Okay.
Yes, madam. Now, madam, I understand that I'm running out of time, so may I have another 2 more minutes to wrap up my submission B?
Yes.
Thank you, ma'am. Thank you very much. So, Madam President, now my next submission is on the mobile phone issue. And I will also proceed in 3 steps. First, I will clarify the proper framing of the issue. This case is not about refusal to cooperate in principle, but rather it's about proportionality of demanding an unrestricted access to the entire phone of the athlete. Second, I will submit that such demands constitutes a disproportionate interference with the private life under Article 8, and particularly where no safeguards, limits, or alternatives were considered. And lastly, I will explain why existence of parallel criminal proceedings reinforces conclusion under Article 6, because compelling disclosure in these circumstances risk a circumventing criminal procedure safeguards. The issue B in this case is not about athletes must cooperate in principle. The issue is whether FIFA was entitled to demand an unrestricted access to an athlete's entire mobile phone while a parallel investigation was going on. Our submission is that the refusal was unlawful, primarily under Article 8 and supported by Article 6 of the ECHR.
But the problem is, for say, if we do not compel the athlete to render his phone, then probably he's going to delete all his contact information, right? Like with the people who might involved with that, the
Yes, Madam President.
manipulation of the matches.
But
Why would you say that it's not disproportionate? Yeah.
Madam President, firstly, we are submitting that our client, Mr. Fortuna, is innocent and he has nothing on his phone, which renders him as guilty. Second, Article 8 specifically states that the right to respect your family life includes letters, uh, telephones, and means of communications, emails as well. So using this flow of logic, we are asserting that submitting our whole phone to the FIFA disciplinary tribunal itself was unlawful, and not the idea that there might be something in there or there might be not be something in there. We are trying to put forward the argument that the request from FIFA is unlawful and they should not be asking for such deliberate request.
What if this tribunal are also interested in the phone?
Madam President, if the tribunal is interested in phone, then we would like to submit that it infringes on the Article 8 of the ECHR.
So basically, you're saying that it's anti-human rights, so it should not be submitted, right?
Yes, Madam President.
Then following that logic, isn't it just impossible for any court in the world to have access to personal phone because it's just anti-human right?
Madam President, using that logic, we are asserting that while the ongoing criminal procedure is going on Mr. Fortuna and his father, the FIFA disciplinary tribunal and this court should not be asking for the phone itself. But once the trial has come to an end, we will be more than happy to submit the phone itself. But for now, we would like to submit that it is inadmissible. Sorry, it is out of proportion to ask for a whole phone of the athlete, which has so much of personal data and is basically a diary of a 21st century man.
Okay, thank you.
Thank you very much, madam. Madam, so the case concerns proportionality, and FIFA, as mentioned earlier, demands unrestricted access to the athlete's entire mobile phone during an ongoing criminal investigation. And criminal investigations without safeguards, and Article 8 squarely engages. And CS jurisprudence also recognizes that the duty to cooperate is not absolute in such circumstances. I would like to end my submission over here. If the panel has no further questions, I would like to now hand my time over to my co-counsel, Mr. Brandon. Thank you.
Thank you.
Madam President, can you hear me clearly?
Yes.
Good evening, Madam President. My name is Brandon Zhang, appearing for the appellant. I will make two submissions on issues 3 and 4, namely whether the anonymous email and anonymous witness statement constitutes admissible evidence, and whether the appellant violated Article 20 of the FIFA Disciplinary Code. The respondent, FIFA, alleges that my client is guilty of match fixing and relies on anonymous evidence to support its claim. We submit that the evidence does not meet the threshold of comfortable satisfaction to establish my client of match fixing. I turn to the first submission. We submit that the two pieces of anonymous evidence is inadmissible for three reasons. First, CAS jurisprudence applies strict safeguards with respect to anonymous evidence, and these safeguards have not been met. And lastly, in the alternative, if the evidence is admitted, it does not meet the threshold and therefore has no material bearing on my client's case. On the evidence, Exhibit 1, no attribution is made out. Exhibit 2, hearsay. Witness refuses cross-examination and therefore is unreliable. Exhibit 3, speculation. Even if admitted, doesn't prove a thing. It is very common now for people to have crypto wallets. Exhibit 4, speculation again, even if admitted, doesn't prove anything, even if it's
Problem
true.
is, right? So the thing is, we're not looking at these pieces of evidence independently. We are looking at all of them together holistically, right? And it seems to me that it's quite a convincing story that the athlete is not playing a legit game because previously he and his father went into a fight. His father tried to force him to play a forced match.
Yes, Madam President. We will bring the panel to the evidence one by one if that is what is requested. In Exhibit 2, if the panel would turn to page 32, paragraph 5 of the record. It's the PDF, page 32, if you have it there.
Okay.
It states that at paragraph 8, he's arguing with his father, and then on the next page at paragraph 9, he specifically tells his father that to stop pressuring him and that shouting that he simply could not go along with him in everything. Madam President, there's two issues with Exhibit 2. First, the identity of the witness has not been confirmed by the court. And second, the context of the evidence is the evidence is out of context. And therefore, we submit that it is inadmissible. I would like to introduce the panel to the 2019 CAS decision of Karamudin versus FIFA, where it was held that the use of protected witnesses, anonymous witnesses, is subject to the following strict conditions: that the witness has to be questioned by the court itself, which must check their identities and the reliability of the statements, and that the witness are cross-examined through an audio-visual protection system. And moreover, on that piece of
Sorry, just to clarify, so this strict restriction you're mentioning about, is it from a case authority or is it from FIFA rules or whatever?
it is from a case authority, the 2019 Court of Sport decision of Karamudin versus FIFA at paragraph 129.
Okay.
These are the strict requirements, and that was Exhibit 2. Exhibit 3 is also inadmissible as well because the identity is not verified. There is a case in the same case, Karamudin, at paragraph 188. The panel held that screenshot messages carries no evidential weight, even if there is a name attached to it, because the appellant had failed to prove its authenticity. And again, this is because
But you see, that's the conflicting party for submissions, right? As in, if you really want the tribunal to find out the authenticity of the screenshot, then maybe the best thing for us to do is to seize the phone of the athlete.
Yes, Madam President. However, as addressed briefly earlier by co-counsel, the request for a mobile phone is a matter of principle and policy. Now, it is it is fundamental to every individual's right that regardless of whether there is evidence or not on the phone, that every human being has the right to defend itself against the privilege of self-incrimination under Article 6 of the European Court of Convention Human Rights. And this was held, Article 6, subsection 1 was held by this tribunal to be indirectly applicable in the 2013 Adamu versus FIFA case at paragraph 66. If there are no questions on submission on the third issue, I will move to the last submission. Turning now to the last issue. If I may, the respondent alleges my client of match fixing under Article 20 of the FIFA Disciplinary Code. We submit my client is not guilty for 3 reasons. First, the evidence does not meet the threshold of comfortable satisfaction. Second, the Genius betting report itself does not constitute match fixing. And third, the performance analysis directly rebuts the allegation and proves my client's innocence. In the 2017 Court of Sport arbitration decision, Oleg's Penkovsky versus LFF at paragraph 84, the panel held that betting fraud match report by itself is insufficient and without further evidence, not sufficient to establish a link between match manipulation. And if I may now bring Madam President to page 15 of the PDF. Is Madam President with me?
Yes.
So I would like to start at goal 2 here at minute 64:04, the last, just at the second line, last word. No individuals were identified in this passage. And below at minute 88:13, at the third line, it says Santiago pulled up with an apparent hamstring injury. And at the last line, it says, not a performance error. The inability of Santiago to continue his recovering run led to the goal being scored. And if Madam President can turn to the next page. Here at minute 61:54, it says Reyes made a run. And at the last sentence, it says the forward awkwardly attempted to backheel the ball, and the ball ended up rolling out of play for an Iridonia goal kick. And at minute 82:43, line 1 states Iridonia's left-sided central defender Paul attempted a diagonal ball back towards his own goal under minimal pressure. And the most compelling evidence is the last line. I quote, though the effort was well saved by the Iridonia goalkeeper Fortuna, my client. And what the performance analysis shows is that my client actually saved the goal, and that 2 of the 3 goals that were scored during the match were not attributed to my client. And moreover, there is suggestions in the play here because Paul, Reyes, and Royce all had performed unexpectedly, and therefore we submit.
But in the 1929, when it's still 0-0, right? Fortuna was positioned over the top of the ball and opted to step the ball out of the play rather than pick up the ball, despite the clear deflection off of the Adornia defender. Is it like a reasonable thing for a footballer to do?
Madam President, we submit yes. In the present case, there are many factors. And the first factor is, according to page 2, paragraph 2, Mr. Antonio Fortuna is a backup goalkeeper for the Iridonia men's team. And Exhibit 8, the day before the game, he consulted his doctor because he was sick and still chose to play. Now,
So the thing that I'm trying to point out is, at first, at the start of the game, Fortuna seems quite passive. At the end of it, it's already 0-3. So for me, it's a clear lose already. Maybe this is time that he think, okay, I should not act anymore.
Madam President, my client was simply trying his best to represent his country in the World Cup. And saving a goal at the very last minute was the only thing that my client could do to redeem himself in the given circumstances of the case. And
Can
I know
just to clarify, what is the element for something to constitute manipulation of a football match?
Madam President, my time is up. May I have the time to answer your question?
Yes, please. Thank you.
Under CAS jurisprudence, under sports law, the burden of proof is the comfortable satisfaction, which gives the panel the discretion to decide if it is comfortable that it meets what we call the mere comfortable satisfaction, which is on balance which is higher than a balance of probabilities, but lower than the criminal beyond a reasonable doubt. However,
I'm not talking about standard of proof or anything like that. I'm asking the elements for something to constitute manipulation of a football match.
the element is that there must be what is called manipulation, and that is a connection on the facts in Article 20 of the FDC is anybody who's directly or indirectly by an act or an omission unlawfully influences or manipulates the course or attempts to. And on the facts, as I have brought Madam President to, there has been no manipulation attributed to my client on the facts. The performance errors in the game was merely due to the pressure of the World Qualifying Cup games, and plus my client was sick and also a backup goalkeeper, and therefore he gave his best in the game. Unless I may be of further assistance, this brings me to the end of my submissions.
Okay, thank you.
Thank you.
Thank you.
Hello.
Hello. Before I begin, could I check if I'm audible?
Yes.
Oh, yeah. Apologies.
It's okay. You can start when you're ready.
Good evening, Madam President. My name is Ramesh Kanna, and together with my co-counsel, Mr. Austin Seah, we appear on behalf of the Respondent, the Fédération Internationale de Football Association. I'll be addressing the first two issues for 10 minutes, namely whether Mr. Fortuna's statement of appeal is admissible, and secondly, whether his refusal to surrender his mobile phone is unlawful. My co-counsel and I will each take 10 minutes for our main submissions, and we respectfully reserve 1 minute for our rebuttals. Now, Madam President, CAS jurisprudence always requires CAS panels to take a stance between procedural fairness and substantive fairness. And on this sliding scale, the stance that CAS panels ought to take has already been set in stone for the overwhelming majority of cases as seen in the CAS Code, It is only in very exceptional circumstances that the CAST panel has to vote in favor of substantive fairness, in
How do
favor
we
of
differentiate if something is substantive or procedural? How do we differentiate between them?
Well, in this case, substantive fairness would go towards the merits of the issue, Madam President. For example, whether indeed this particular article of the FDC has been breached, and procedural fairness would go towards whether the procedures have been duly complied with. So with regard to the first issue, in terms of admitting the statement of appeal, procedural fairness would go towards equal treatment of the parties in ensuring that both parties get the same amount of time to submit their statements of appeal. And with regard to the CAST code, there's no issue with regard to when the window for the deadline begins. Opposing counsel submissions centered a lot on the fact that the deadline window began on the 2nd of April. This the respondent has no issue with. We do not contend that the deadline begins as early as 31st March. However, what opposing counsel has conveniently left out is that R31 of the CAST code requires electronic filing to occur, electronic filing to only be counted as received when it has reached the CAST office. And in the present case, whatever email was sent by the appellant did not leave the appellant's server to reach the inbox of the recipient.
Sorry to bother you. Can you direct me to the specific pages in the CAST code that you have sent in e-version? For the e-filing basis, is the receiving date with counts as the
Yes, Madam President. Could I refer you to R31 of the CAST code?
R31 is page number.
Unfortunately, I'm not. Give me a second. Apologies.
No worries. Okay, I found it. Yeah, it's page 12.
Yes. So this states that specifically for electronic filings, receipt requires that it has reached the recipient. And in this case, whatever email was filed never left the sender's servers because it never reached the inbox of the CAST office. And this is proven by the screenshot that the opposing counsel himself relies on, where the IT management operators tell the respondent that whatever issue that they were facing did not allow for emails to be sent out.
Okay, but then if really following your reasoning, isn't it going to the fairness stuff that we're talking about? If we're just going to borrow the claims for the poor person, then there's nothing they can do because it's not due to their own fault. It's due to some unfortunate events happening out there, right?
Definitely, Madam President. So in circumstances like this, the CAST panel has to consider the overarching circumstances to see if reinstatement of the deadline would be the fair thing to do. And this is what
Okay.
I had earlier mentioned.
I think let's save the time, as in how do you respond to the case authorities that the appellant has mentioned about that the cast has facing the exact same issue about the technical problem, but then the tribunal is still willing to admit the case.
Madam President, to answer that question directly with regard to what are the legal standards to be met for reinstatement to be provided, opposing counsel has not stated what legal authority they rely upon. However, the legal authority that the respondent relies upon would be the 2024 CAST decision of FC Football Club and Galatasaray AS, and the 2019 CAST decision of PFC and UEFA. Both these cases state that two elements conjunctively have to be met in order for reinstatement to be provided, and that is there must be no fault on the sender for the statement of appeal not being sent on time. And secondly, there must have been promptness on the part of the sender in requesting for reinstatement. Now,
So you think cyber attack is the fault on the sender?
yes, Madam President, and I'll explain why. The no fault element is a threshold issue. And to understand what is the threshold to be considered of being at no fault, we should look at CAST jurisprudence. So if we look at the 2023 Swiss Federal Tribunal decision, B and FIFA, in this particular case, the advocate that was representing the applicant had fallen ill due to a severe medical crisis. And by reason of that, they could not send the required
But
documents.
that is very different from our scenario, right? That is medical symptom, but here we're talking about technical issue, which sounds more like the, if I didn't get it wrong, it's the 2019 case authority mentioned by the appellant.
Yes, Madam President, but even if we were to take that particular authority, in the context of an email, first of all, the principle that's applicable to the case that we refer to and the present case is still one that is common, which is that when there's an issue that prevents the individual from sending their document in time, the CAS panel ought to see when they had began to submit. In this particular case, they had submitted at 23:45 of the day prior to the deadline ending. And this is analogous to the case that I had stated because although the issue was a medical issue, we would argue that that was actually far more severe compared to one that we see here. And the CAS
But
panel
the problem
rejected.
is the elements that you're talking about is whether there's fault on the sender, right? Medical condition you consider as fault, or cyber attack you consider as fault. Which one is more at fault? Because we always want to tie back to the elements, right?
Yes, Madam President, neither is actually at fault. What the case that we were referring to pointed to was the fact that the advocate chose not to start on the submissions of the appeals any earlier prior to his medical condition acting up. And that's the similar thread that we're trying to draw in the present case, which is that an email could have been sent much earlier rather than at 23:45. And when they are sending such a time-critical email so close to the deadline, they chose not to check if it has left
Actually,
their
it's
inbox.
not very rare in practice, because in practice, people purposefully choose a Christmas night, a Christmas Eve, or like a CNY dinner time to send out things just to trick the other side. So, how do you reconcile about that point?
Well, in this regard, Madam President, we would just like to end with the fact that if the email had not been sent out, an error message would have followed, and it would have been part of their due diligence to have checked if it has left their inbox. The fact that they didn't even take this very simple measure shows that there's blatant disregard for procedural frameworks. And I move forward to show that the appeal brief had also been sent late. With regard to Article R32 of the CAS Code, the applicable deadline was 4th May 2026, yet they submitted it one day later. Thus, this continuous pattern of disregard for procedural certainty is what the respondent finds issue with. And thus, we state that in this particular case, neither requirement of promptness nor no fault on sender was met. If Madam President has no further issues, I note that I've exactly 1 minute left. Could I request for an added 1 more minute to sum up my submissions for the second issue?
Yes.
Now, with regard to the second issue, opposing counsel's argument stands on two grounds. Firstly, they rely on Article 8 on the right to privacy, and secondly, they rely on Article 6 on the right against self-incrimination. While we do not contest against the fact that these two articles are applicable by reason of the fact that this panel sits in Switzerland, what we do contend against is the fact that the threshold for both of these articles have been met. Now, with regard to Article 8's right to privacy, I note that Madam President had questioned opposing counsel earlier on if this were to be applied wholesale, then in any particular case of sports arbitration, we would be denied of an opportunity to look into evidence. And that's presently the case as well, because as it will be certain in the next issue, opposing counsel's main arguments regarding issues C and D is the fact that there is not enough evidence to make a proper understanding of whether Article 20 has been breached. And if we were to apply Article 8 wholesale, it would be a fatal blow to the regulatory system of sports. Unlike state authorities, sports governing bodies lack coercive powers, such as the ability to issue search warrants, and must therefore rely on mandatory duty of members to provide evidence. Now, we have to consider this.
You direct me to the point that FIFA do have the power to compel the athletes and members to adduce evidence.
Yes, Madam President. If I could refer you to Article 12 of the FDC. At subsection 3, it states persons subject to this code shall help to establish and / or clarify the facts of a case or any possible breaches in this code, and in particular, they shall provide any evidence requested. Now, on its face, it might seem that it's absolute, but this has to be read in together with the context that Article 6 and Article 8, with which opposing counsel rely upon, are for criminal proceedings, a situation where the state is unmatched, has unmatched power for evidential findings, whereas in the present case, a body like FIFA does not have that. Now, I note that my time has elapsed. If Madam President has any questions regarding Article 6, I would be happy to answer them.
I don't really have. Yeah, but I think, I don't know. I'll leave my comments later. Yeah.
Madam President, before I begin, can I confirm that I'm audible and you can see me clearly?
Yes.
Good evening, Madam President. My name is Austin Seah, as earlier introduced by my co-counsel, and I'll be addressing the next two issues on appeal. Turning to the third issue, we submit that anonymous witness statement and email constitute admissible evidence as it meets the requisite conditions for admission under Article 6 of the ECHR. So, we have to understand that this tribunal is seated in Switzerland, and as a result, the procedural validity of these proceedings are also governed by Swiss law, specifically Articles 182 subsection 3 and Articles 190 subsection 2 of the Swiss Private International Law Act. And CARE's jurisprudence has consistently held that the requirement to be heard read in conjunction with Article 6 of the ECHR is prudent to our case, and to lay out the elements as to whether this panel can rely on anonymous evidence, it is threefold. Firstly, there must be...
Information about the seat of arbitration is Switzerland.
Yes. And this can be found in R32 of the CAS Code, Madam President.
Okay, and may I know which rule, article, or section under the Switzerland Arbitration Act is about setting aside the award?
Madam President, what we are contending here is not setting aside the award, rather it's about the admissibility of anonymous evidence.
Exactly.
Yes.
But think about it. If, for say, the tribunal has misused its power to admit a case which should not be admissible, then we are going to face with the challenge of the award being set aside. So this is the reason why I'm checking with you. Do you know about that?
Unfortunately, Madam President, I'm not too sure on that right now, but if we put aside the anonymous witness statement and the email, this panel can still rely on Exhibit 1, which is a genius report, to make a finding as to whether the appellant is liable for match manipulation.
Okay.
And now-
Another thing that may be on the tribunal's mind is, will we get into trouble by, I don't know, illegally obtain evidence or anything related to that?
Madam President, following a few of the CAS jurisprudence, there has been no outright declaration by the courts as to any punishment or sanctions to the CAS panel if they were to rely on any such evidence. And to establish why this will not happen in our case, there are three reasons that have been met by both strands of evidence. Firstly, there was good reason for non-attendance. Secondly, the evidence is not sole or decisive. And thirdly, there are counterbalancing factors that safeguard fair assessment of reliability. In regards to the first element, we do agree with counsel for the appellant that the 2019 case of Karim Karamuddin is applicable. And in that case, the panel noted that it does not require proof of concrete evidence, concrete threats, or past violence. Rather, it assesses whether there's a real risk based on the context. And in that case, the CAS had accepted anonymity because allegations went beyond sporting misconduct and engaged criminal conduct similar to our case, where it was exercised by a powerful individual in a context where witnesses were vulnerable. And the same structural features arises here. This case involves alleged sports manipulation, alleged criminal networks, and substantial cryptocurrency transactions, with the public prosecutor confirming that there are ongoing criminal investigations.
Actually,
This-
personally, I'm okay with this idea of anonymous evidence. But the
Certainly.
problem and concern of this tribunal is that how are we going to verify the authenticity of the evidence produced if we cannot do cross-examination?
Certainly, Madam President. And I note that the appellant claims that there's been no verification as regards to the witness statement. However, if I may turn Madam President's attention to paragraph 4 of the witness statement.
Paragraph 4 is page number
This will be at PDF page number the 38.
38.
Well, apologies, Madam President. The anonymous witness statement will be 32.
32, okay.
Yes. At paragraph 4, the very first line is stated, following my interview with FIFA. So the fact is that FIFA had actually interviewed this individual, and it's not that the witness statement has been fabricated by somebody that the FIFA doesn't even know about. And secondly, and
But
most
you see, the
crucially,
thing here is, right, the only person, legal person that has ever heard about these witness statement is FIFA. But here you are actually on the respondent seat.
Mm.
So wouldn't it create any problem that relating to, for example, if you're biased? Because your legal interest is involved in this case, right?
certainly, Madam President, and I'll answer a question in two parts. Firstly, we have to consider the wishes of the witness himself, specifically in what context he wants to provide evidence. The accused had already expressed fear that he might get threatened or worse, injured by the criminal organizations Mr. Fortuna could have been part of, and this can be seen at PDF page 32, paragraph 6. And now turning to the issue of internal and external consistency, in Karamuddin, the case emphasized that internal consistency is a key testing mechanism when there's a case where the case is unable to verify or cross-examine witnesses. The panel assessed whether the anonymous statements were coherent, whether they acknowledge their own limitations, and whether they avoid exaggeration. And turning to our case, this is directly analogous because the witness recounts a specific contemporaneous observation, a stress phone call before the match, as noted by Madam President in his question to the appellant. And while expressly acknowledging the limits of what he could hear or know, as in Karamuddin, the witness had similarly not speculate about betting or criminal arrangements, but confines the account to what he personally observed. And this internal
And also
restraint.
the second thing that I want to point out is that even if we're taking the anonymous statement of the witness, right? But then just based on whatever that was heard by the witness, it actually doesn't tell the whole story. It seems to me that they can be just having a normal fight, right?
Hmm.
It's like, stop pressuring me, and that's it. It could be pressure about other stuff in personal life, maybe.
Certainly, Madam President, and I know that I'll be addressing this in the last issue, but I can actually draw a connection between the phone call that was between the appellant's father and the betting reports. And if I may turn Madam President's attention to well, the anonymous witness describes a tense and stress on the night of 16 October 2025, specifically overhearing his father to stop pressuring him. And if I may turn the panel's attention now to the Genius Report Exhibit 1, under the title Genius Report titled Match Result / Asian Handicap, you can Command F Asian Handicap to find that specific section.
Come again, like how to spell this Asian handicap?
ASIAN.
Asian, okay.
Yeah. Handicap, HAN.
Handicap, okay.
So specifically under this part, 12 hours before the match started, betting support had started to pick up pace, and the timing specifically aligns with the pressure described by the witness on the evening of the 16th. Now, taking these two strands of evidence together, it does show a level of corroboration. And I note that my time is elapsing soon. If I may turn to the final issue, unless there are any further questions.
Yes, you can turn to the final issue. Wrapping
Thank
up in 1 minute, if it's okay.
Certainly, I do have 3 minutes left based on my
Oh,
clock.
okay, sorry.
Yeah, no worries, Madam President. Turning to the last issue, we submit that the appellant had violated Article 20 of the FDC. And earlier, Madam President asked an extremely crucial question to the appellant as to whether we should be assessing the evidence as a whole And this is precisely the framework set forth in the 2009 CAS decision of FK Pobeda and UEFA, which recognized that match manipulation is, and I quote, rarely proven by a smoking gun. And therefore, the CAS must assess evidence globally to reach a comfortable satisfaction threshold from a converging set of circumstantial indicators, which is explicit. And now turning to the elements as earlier queried by Madam President to the appellant, there are four elements to be met. And firstly, the act or omission must be attributable to the appellant that manipulates the course of the match. And turning to that in our case, the Genius report highlights specific below-level goalkeeping decisions. And if I may turn Madam President to one such evidence, it will be the 23-21 area under the subsection of goals located in Exhibit 1. And this can be located at PDF page 15. Under 23-21 itself, it stated that Fortuna attempts a lofted pass, and a pass height is misjudged, and a command line forward intercepts and rolls it into an empty net. And turning to the next page, at the 5-minute and 54 mark, if Madam President is with me, a corner passed through Fortuna's hands. And these are acts or decisions that directly shape match events. And I note that the counsel for the appellant has also alleged that Mr. Fortuna was a substitute and that he was sick in the context of the match. And I will address these two issues in turn. Turning to the fact that he was a substitute, firstly, it was not the first time that he was playing as a goalkeeper. If I may turn Madam President to page 2 of the record, paragraph 2. It stated that he has a good season, building a solid reputation in this case, and therefore we cannot discount the fact that he was actually a good goalkeeper. And this was also confirmed by his manager that noted that he has been great all campaign and kept us in matches single-handedly. And this shows that the manager acknowledges Mr. Fortuna's impact on the game. And turning to the appellant's second assertion that he was sick, as rightfully pointed out by Madam President, in the passages of interest at 82-43, it was the last 80 minutes of the game. And if the appellant was truly sick, he would have sustained that sickness together with the fact that he was fatigued from 80 minutes of playing all the way to the end, and yet he was still able to save an extremely difficult goal. And therefore, these conscientious decisions made by the appellant in the context of the match does show that the fact that he was sick is probably a mere assertion that has not been put forth or substantiated in any way. And I'll note that my time has elapsed. If I may have 1 minute to further sum up my last two factors.
Yes, please.
Thank you, Madam President. And turning to the third factor, we have to establish that there was a conspiracy, and as earlier addressed by my submission regarding the handphone call, there is a direct correlation between the handphone call and the increased betting support, as noted in the Genius Sports report. And with regards to the last element, we submit that there's an objective backbone that ties all of the elements together, the Genius report. Because the anonymous email asserts that Mr. Luck Fortuna had received $50,000 in cryptocurrency, and on the Genius report itself, a leading crypto bookmaker had reported that there's been more Bitcoins or cryptocurrency on this match than all other regional World Cup qualifier matches combined. And this directly validates the anonymous evidence claims that manipulation was funded and executed via cryptocurrency. And unless I may be of further assistance to the panel.
I think there's one thing that I'm quite curious about. So is Mr. Fortuna injured during the pre-match, or he's injured throughout both pre-match and the match that's
Madam President, I believe that it's only for the current match.
okay, understand. Yep, thank you.
Thank you, Madam President.
We can start when you're ready.
Madam President, 1 point in rebuttal. the respondent submits that Exhibit 2 is admissible. We say this is incorrect. In Kerimudin versus FIFA, the athlete was granted asylum and he had to go through the audio-visual protection system. In our case, FIFA is the only person to interview this player, and FIFA has also interviewed other players on the team. However, this anonymous witness is the only person to have this interview. And furthermore, this athlete refuses witness protection, and the audiovisual protection system protects the identity through visual and audio protection. And therefore, we submit that without the verification of identity and cross-examination, that the evidence is inadmissible. This concludes my rebuttal.
Thank you.
Before I begin, can I confirm that I'm audible and visible, Madam President?
Yes.
Thank you. Madam President, one point in Sir rebuttal. The appellant has contended that the witness in our case had refused to undergo a witness protection program, but on the facts, there shows no evidence of that. And he similarly analogizes to Kerimudin, where there was a voice scrambler in place. Well, we have to consider first that if we truly force this witness to testify, he may not have even wanted to produce the witness statement, making it even more difficult to make out a claim of match manipulation, as the appellant has already asserted that he does not wish to hand over his phone. And if we do take that into consideration, this panel is limited by very limited facts to make out a claim of match manipulation. And furthermore, noting that the appellant's father is part of a large criminal organization, it is very plausible that a man of his capabilities can bypass such video audio scramblers or have insider information as to the witness, as notably based on an uncontested fact. The identity of the witness is within a mere team of 10 individuals, making this identification rather simple. And unless I may be of further assistance to the panel.
It's okay. Thank you.
Thank you, Madam President. This concludes my submissions.
Okay.
We can take a short break if you would like before comments.
It's okay. I'm good with all. Yeah.
Yeah, we can go through comments. Yeah.
Mm.
Yeah, sure. No, it's okay. We can stay inside. You.
Okay. Yeah.
We're gonna stop recording or
Oh yeah, I can stop recording on the. Yeah.